So this is the tenant rights and responsibilities session. And there you are, Robert, yay. So I'm seeing the chat, I'm monitoring that. Marina Zender from our office is also here. And I just wanted to quickly invite Monique, Wright, Williams, or Rachel Fleming to say a quick hello if they would like to, as they're so gracious to host us.
Sure, I'll just say welcome to everyone who's in on this webinar. And this is one of the initiatives of the Office of Family Engagement with the support of the Volunteer Lawyers Project and Hiscock Global Aid and other partners. So thank you very much for joining us. And please be mindful, we have co-video chats every Tuesday and Thursday as well.
Great. Rachel, you have anything or just want to say hi to everybody?
Hi, everybody. My name is Rachel Fleming. I am the administrative aide for the Office of Family Engagement with Syracuse City School District. And if anyone has any questions after all of this or needs any help with anything, I can be the go-between between the school district and these amazing organizations. So thank you.
Cool. And I want to go over again, just some ground rules so sort of people understand. First of all, again, if you weren't here earlier for that, the questions go in the Q&A box. They need to be typed in because participants who are not on the panel are not visible and we can't hear you, unfortunately, because this is structured as a webinar, not your typical Zoom meeting where you can connect and everybody can talk. So that's just because it's such a large group. We wanted to make sure that everybody has an opportunity to be heard, and that chat box and the Q&A specifically are being monitored. So we'll make sure that we try to answer any questions that people have. So the other thing is that lawyers like lawyer language, so sorry about that. But I do think it's important that everyone understand as a basis of this, that this is not creating any type of attorney-client relationship. This is not to address people's very specific questions about your specific situation. It's basically to provide general knowledge and information about what the law is. And then if you have specific questions about your specific situation, we would want you to contact an attorney for that. This is a basic know your rights presentation and does not create any attorney-client relationship. And I just think that's super important for everyone to understand. And if you do have questions that we put in the chat box, we can provide general information about the law, but that's not meaning that we're representing anyone. So I hope that is clear. And thank you. Oh, good. Susan, you're in. Hi. You came back up. They call you Diane on there, but Diane, thank you for helping Susan get in. We can't hear you because you're muted, but you can unmute yourself in the bottom left corner. All right, well, Marina, maybe when I'm done, I will go in and see if I can unmute you, Susan. But for now, I'm just going to do a little session. I think everyone needs to know a little bit about what's happening now. Let's go into 10 minutes in. Thank you all for your patience in all of this. Let's talk a little bit about what's happening now. What are tenant rights and responsibilities specifically related to COVID-19? There are a lot of rumors flying around, and we just want everyone to feel comfortable and clear on what the law is now. Right now, there are no evictions in New York State, period. For health and safety reasons, there is a complete moratorium on all evictions. Some of the state websites say until June 20th, some say until June 19th. June 20th is a Saturday, so we're talking Monday the 22nd before anyone could actually legally be locked out of their apartment in the entire state. So there is some time built into everything, and just understanding that will help us understand some of the next things we're going to be talking about. If you are in federally financed housing, Susan's going to be getting into that. There are no evictions for federally financed housing until at least August 27th. There are no court processes right now, but that could change very soon. There may be opportunities for landlords to bring people to court and to get those orders, even though they can't actually act on them until late June. But what does that mean? Does that mean you don't have to pay your rent? Does that mean that you have to deal with horrible conditions in your property? Let's see. Rent is still legally and contractually due. So when we go to landlord-tenant court, about 85 to 90% of evictions are based on a claim of non-payment of rent. If you don't pay your rent, the landlord can evict you. It's repo law 101. But the situation that we have here is that people aren't able to pay their rent sometimes, and that can be a real issue. What we would advise everyone to do during this time is that if you possibly can pay your rent and you want to try to avoid eviction in the future, pay your rent. If you are concerned about unemployment insurance benefits or other benefits that you may need to try to, or you may need help accessing, I would suggest talking to case managers, legal service agency providers, so that you can try to access whatever benefits or stimulus checks may be coming your way. But eventually it will catch up. And this is part of the concern that we have as legal service agencies, because right now there is no legal provision to waive rent during this time. Rent is still due legally. That might change. There are some proposals out there, but nothing has been passed. We don't know for sure that anything will be passed. Late fees can still be charged legally based on everything as it is in place right now. Again, that could potentially change by the time we end up back in court. But right now, they still could be added on. So paying your rent in full to avoid potential fees is probably a good idea if you possibly can. So I just want everyone to understand that. However, a landlord still is obligated to maintain your property in good shape even if you can't pay your rent. And Robert's going to be talking about that in the near future. Legally, only an officer of the court, a marshal or a sheriff, can actually lock someone out or evict you. So a landlord, the landlord's best friend, his brother, his dad, sister, none of them have the right to evict someone on their own. It is called a self-help eviction. It's illegal. It's a crime. And you want to, if a landlord tries to lock you out, change your locks, break your locks, take down your door, tries to turn off any essential services like water, power, heat, if they try to deprive you of the use of necessary appliances that they've provided, like your oven or your stove or your refrigerator, all of those things, if they're doing those things because they're trying to get you to leave, that's a problem. And any overt and repeated harassment can also be a problem. And safety issues, habitability issues still could be considered essential cases that tenants could potentially bring against landlords, even though the landlords can't bring cases to evict. So I just want everyone to know you still have those rights. And if a landlord tries to evict you on their own, or they try to force you to leave in spite of this moratorium, you want to first call the police, because you have a right to be there during this time. And second, call an attorney, contact one of our legal service agencies, and we're going to make sure that you have access to information on how to reach out to all of our agencies when this is all done. We're going to be sending a follow-up email. I've already provided Rachel with our contact information sheets. Also, if you have been in the or if the landlord wants to change anything about your rental relationship, as far as how much you pay for rent or how long your rental period is going to last, they have to give you proper notice. And it's really important that you know that. It's now changed based on the new laws from last year that came into effect. So everyone knows what a 30-day notice is. You get a 30-day notice if they're not going to renew your lease, or they're ending a month-to-month lease, or they're going to change your rent. But now that 30-day notice has changed for tenants. A tenant still has to give a landlord 30 days notice if they're going to leave or change anything, but if they're on a month-to-month. But a landlord now has to base the notice that they give on the length of time a tenant has been there, so length of occupancy. So if your landlord suddenly is deciding, well, you're staying there, I'm raising your rent $200 a month, and you're a month-to-month tenant, but you've been there 2 years, you actually have a right to a 90-day written notice. So it's based on how long you've been there. If you've been there for less than a year and you're on a month-to-month, you get your 30 days notice. That's the same. But if you've been there from a year to 2 years, it's now 60 days notice. And if it's over 2 years, it's a 90 days notice and in writing. So also, say your landlord's like, okay, you've been there a year and a half, I'm giving you 60 days notice that I'm going to raise your rent by $200 a month, and you don't agree and you don't sign anything, keep paying the rent you've been paying. They can't evict you for that increase unless you've agreed to it in writing, and they also can't evict you at all during this time. So eventually it will come around, but if you don't agree, that means basically eventually you're planning to move, or you're not planning to stay there for that. Let's see, okay. My notes just went off on my screen here. I'm working off this other screen and it just disappeared. It went blank. So I want to introduce Robert Rubinstein, who is an attorney with Hiscock Legal Aid Society. And because we are in this eviction moratorium, which means no evictions, we've been getting a lot of calls about landlords not taking care of the property, not following up on their end of the bargain, and saying, well, I'm not going to fix something because you're not paying the rent, because you can't pay the rent during this time. And so first, we want to remind you all and know that you are safe from eviction during this time. It will end, but during this time, you also have the right to a habitable and safe place to live. And Robert's going to talk about that now. Can you unmute yourself, or do you need me to do it?
I got it. Thank you, Laurie. So my name is Robert Rubinstein. I'm the lead landlord-tenant attorney with Hiscock Legal Aid, one of the 3 agencies that operates here within the city of Syracuse. Our agency primarily deals with tenants who live in what we call private housing. That is, you rent from a private landlord. There's no state or federally involved aspect to your tenancy. We have a general intake number, and that will be getting out to all of you along with the rest of the contact information for all of our agencies. But I'm going to discuss the issue of repairs. That is something that I am sure is a big concern for many of us in this time, especially where we're not able to go places. We can't do anything. And who are we supposed to contact? Who are we supposed to tell? And what should we be expecting from our landlords? So Laurie was touching on this. The landlord is still responsible for maintaining your property. That does not go away just because of the current health situation regarding COVID-19. You should notify your landlord of any of these issues that are going on. Doesn't matter how small the issue is or how large the issue is. You should always notify them. And I would recommend that you document them. If you are calling them, make a note of when you've called them, make a note of why you called them, about what issue it is. The landlord should be taking some steps to come in and take care of the repairs. If it's just a general repair issue, they should be giving you at least 24 hours notice to let you know that they're going to be coming in. The only time that your landlord should be coming in before that is if it's an emergency repair. And that's something like the boiler stops working, the furnace cuts out, things like that. If there's a severe structural issue that they have to get in there immediately, those are the only real situations that your landlord should be coming in without giving you proper notice. Your landlord should not be trying to use COVID-19 as an excuse to not do repairs. The governor's orders do not prevent essential construction from being stopped. That is something that we feel that these repairs are essential construction and that the right to live in decent habitable housing is an essential matter under all of what's currently going on. Your rights as the tenant, let the landlord know. Obviously, I've said that. Let the landlord know that you have these repair issues. If the landlord, after telling him or her or the property manager, whoever it is that you deal with, you need to give them a reasonable amount of time. Usually it's something about a day or a couple of days, because sometimes they may need to make arrangements for a contractor to come in and take care of the work themselves. But if nothing happens, there is an option which we refer to as repair and deduct. This is where if you are able to take care of the repair yourself, or you are able to get a contractor in to take care of the issue, you may do so. You can pay for the cost of the repair or the materials if you're doing it yourself, and you can deduct that from that month's rent. The only way that you can show that this is a deductible amount is either receipts for the cost of the materials, or by having an invoice from the contractor that you've brought in showing that invoice has been paid. Landlords tend not to like this, and that, is not something that they should not be acting on it. The fact that they were given an opportunity to make the repair and failed to do so should not come back on you. Unfortunately, there are some landlords out there who feel otherwise. And in those situations, please contact any of our agencies and we will do what we can to make sure that those issues are addressed, whether by a phone call, a letter, or dealt with in court if necessary. If you're not able to pay for the repair yourself, or you don't know how to do the repair yourself, you do have the option of calling the Syracuse City Code Enforcement Agency, or the department. I don't know how many of you have their number, but the phone number for code enforcement is 315-448-8695, and that is the number that you would call to make a complaint. Currently at this time, code enforcement is not doing a lot of in-person inspections like we would normally expect. Obviously, this is due to COVID-19. They are trying to make sure that not only are they protecting you, the residents, but also their employees as well from spreading the virus and doing their part to, as everyone loves to say, flatten the curve. However, they will do an inspection in person for specific major issues. Those are a lack of heat, sewage backup, an infestation, major structural issues, and a lack of running water. For those specific issues, they will send an inspector out to do an inspection. If the issue that you have is not considered major under that list, you can ask that the inspector do a virtual inspection. This is in a way similar to like what we're doing right now. It's a virtual teleconference where you will walk around the property with a camera showing the inspector what the problems are. They will then make a note of those issues and they can then issue a violation notice to the landlord, giving them a comply by date to take care of the problem. If nothing happens, that is, if the landlord does not do any of the repairs that they're supposed to, please call code enforcement. They will not know if the landlord has done anything unless you tell them whether it's been done or not. The reason we say this is a lot of times code enforcement will just contact the landlord and the landlord might say, oh yeah, I took care of that a week ago, or I've got somebody coming in tomorrow, and code enforcement might just say, okay, then we'll mark it as dealt with. Please do not let your landlords get away with that. Please follow up with code enforcement if nothing gets done. I'm gonna move into the area of an illegal lockout or self-help evictions. As Laurie had said, these are completely illegal. No one in the state of New York has the right to remove another person from a rental property without an order of the court. And even then, the appropriate authority has to be the person performing that eviction. Here in the city of Syracuse, that is the city marshal. There are only 2 marshals, and they're the only ones charged with that ability. So if the landlord or their brother, their mother, their daughter, some family member, or Joe Schmo off the street says, yeah, your landlord said I've got to take you out of here, that is not legal. And you should immediately call the police and have the police come over and take care of it. The police have been made aware that this is now a Class A misdemeanor. Your landlord and anyone else that they employ to try and commit an act of self-help eviction can face jail time as well as civil penalties and fines. After you've called the police, please call our agencies. We will do what needs to be done in the courts to make sure that the illegal eviction is dealt with appropriately, that the landlord is essentially told that what they've done is wrong. Damages can be requested, as well as that civil penalty, which is anywhere from $1,000 to $10,000. That's a lot of money for a landlord to have to be penalized with, on top of any damages that the court would award. In addition to reaching out to our agency and the police, we would also ask that you contact the DA's office. The DA's office will investigate these on their end, and they will prosecute these landlords on the criminal side of things. And I will obviously take questions when we're able to. At this point, I'm going to hand it over to my colleague, Diane Williamson, who is another attorney at Hiscock Legal Aid, who will be discussing the eviction process.
Good afternoon, everyone. My name is Diane Williamson. I work at Hiscock Legal Aid. I go to landlord-tenant court every morning, except for now. The courts are closed, like Laurie said. The best way to get into contact with me or with Rob is to call our intake line. The number is 315-422-8191, and I'm sure Laurie will put that in the comments or email that information. Before I start, I'd like to start with a personal public service announcement. Everyone keeps saying in these uncertain times, yada, yada, yada. I just want to remind everyone that just because we do not know what the future holds, it doesn't mean that the future is going to be bad. A year ago, I was about ready to graduate from law school and I didn't have a job lined up. I was terrified. One of my professors decided to devote class time to a touchy-feely exercise where we were supposed to write letters to our future selves, a year in the future. I started out my letter with something like, "Dear future self, I hope you are okay." And then I went out into the hallway and cried. Of course, everyone kept telling me that everything was going to work out, but still, dealing with uncertainty is stressful. Nevertheless, everything did work out. I got a job and my life is much better now than it was a year ago. Uncertainty does not mean doom. And that's also the case in eviction court. There are new laws that give tenants a lot more time with the eviction process, and the key is using that time wisely. So I'm going to go over what the eviction process is normally when the courts are open, with the understanding, like Laurie said, right now there's a moratorium on evictions until at least June 22nd. Someone asked, what's the eviction process for somebody who has a month-to-month lease? What I'm about to explain is the same for whether you have a month-to-month lease, a year-long lease, an oral lease, a written lease. In order to evict you, your landlord must take you to court. There are two grounds for an eviction: not paying your rent and because your landlord simply wants you to leave. Let's start with what happens if you don't pay your rent. Normally, if your landlord wants to take you to court for not paying your rent, he must give you a 14-day notice. This piece of paper must itemize how much you owe and state that you have either 14 days to pay or move out. This piece of paper must be properly served, or else the eventual court date can be dismissed. Court case. You can go ahead and contact a lawyer at any point during this timeline, or if you just have a question ahead of time. So let's say that you don't pay your rent and the 14 days elapses. You will then get served with court papers, which will give you a court date. When you go to court, the issue will be how much you owe. At that time, you can bring up any codes violations that might reduce the amount the apartment is worth. And I should say that there will be a judgment against you, in court, there will be a judgment against you. That means the court decides how much you are obligated to pay the landlord, and an eviction will be ordered. This amount is only going to be back rent. There's not going to be any late fees included in the judgment amount. Nor will the judge take into consideration whether you've paid a security deposit. It's just going to be rent that the judge is going to be looking at. And if you have receipts, if you say that you paid, then that's what you fight about in court, how much you owe. If you pay the judgment amount before the eviction takes place, the eviction is canceled. So that's new, and that's a big deal. At any point in time before the eviction takes place, if you pay the amount that the court determines that you owe, the eviction is canceled. After court, the landlord will have to go and request the eviction from the city marshal. The marshal will then send you notice of the eviction. That notice of the eviction gives you another 14 days. Hopefully, if you don't plan on paying the judgment, you will have already found a new place. If your landlord does not want to take the money that you owe him, you can go and pay at the court clerk's office. Sometimes we recommend you do that just so that there's no funny business. While there's a good amount of time between not paying your rent and being evicted, especially now with the moratorium, it takes a lot of time to find a new place and to move. You can also during this time request assistance from the Department of Social Services and from Catholic Charities. And we have heard informally that Catholic Charities is going to be having more money coming in to assist people in paying their back rent. So you need all that time to figure out what you're going to do. Now, the second way a landlord can evict you, remember I said there are two ways you can get brought to landlord-tenant court, is that if he simply wants you out. Now this is what Laurie said with the 30, 60, 90 days. If you have been living in the apartment less than a year, your landlord needs to give you 30 days notice that he wants you to leave. If you've been living there between 1 and 2 years, you must get 60 days notice. And if you've been living there over 2 years, you need to get 90 days notice that your landlord wants you to leave. This notice does not need to be in writing, and it does not need to be properly served. The landlord only needs to be able to prove to the court that he gave you the notice. Then when the 30, 60, or 90-day time period is up, your landlord can take you to court. Again, you will be served with court papers. You will get a court date. In this scenario, there's less to fight over. You can argue that your landlord is evicting you as retaliation for expressing your rights, like for calling codes. And if we convince the judge of that, then you won't be evicted. Or if you weren't given the right amount of time, your eviction date can be set farther in the future. But the least amount of time you will get after court is the 14 days notice from the marshal that I mentioned before. So let me share with you a graphic that just helps you visualize this process. So before court, we have one of two scenarios. We have the non-payment scenario and we have the holdover scenario. So with non-payment, you get a 14-day notice, then you get court papers, and you can pay the amount that the judge determines that you owe any point before the eviction is carried out in order to cancel the eviction. With the holdover proceeding, you get 30, 60, 90-day notice. You then get court papers, but it's not an issue of how much you owe. So there's no amount you can pay to cancel the eviction. So the jargon you will be hearing from us, or if you go to court, is you'll get a judgment and an order and warrant of eviction. That means that the landlord has the right to go and ask the marshal to evict you. And then that's court. In court, there will be a judgment if it's a non-payment proceeding and an order and warrant of eviction, or just an order and warrant of eviction if it's a holdover proceeding. And then after court, you will get notice from the marshal that the eviction is going to take place, and that will be at least 14 more days. That's all I got. So now we have Susan from Legal Services of CNY, and she's going to be talking about what applies if you have subsidized housing.
Thanks, Diane. And I'm the one that's also called Diane Williamson on your screen, but I'm really Susan Griffith. My colleagues can tell you sometimes I'm a little technologically challenged, so I appreciate the help. I am from Legal Services of Central New York. I'm the managing attorney for the advocacy group, and we handle many evictions a year, and also give a lot of landlord-tenant advice. And we are specialists in the area of subsidized housing and Section 8. People get called Syracuse Housing Authority. And there are other federal subsidies that are not so easily identifiable, but we handle those cases in the city and in neighboring outlying areas. I'm not going to spend a lot of time talking about this, but there are some things that you should know in dealing with subsidized cases. One is a housing subsidy, Section 8, or any other kind of subsidy that you may receive on your housing is an incredibly valuable asset. It means generally that you're only going to pay 30% of, no more than 30% of your income for rent. But if you lose it, it's often a lifetime loss. So if you are in subsidized housing, it is critically important to be able to keep that subsidy, because most of the people that get subsidies cannot afford to pay full market rent. You pay a portion of the rent that is more affordable to you. So if you lose that, you lose that for time going on, and that is a horrible loss for people. So it is important to stay on top of any papers that you might receive. and it is important to make sure you get legal assistance whenever you can. So please reach out to us. Again, Laurie will distribute our contact information, but it is incredibly important. Now, Laurie talked to you about the moratorium statewide, and that of course applies to federal properties as well, but they have gone, the federal properties have gone a step further. So if it's a non-payment eviction that you're involved in, the Federal CARES Act that was just passed just shortly a while ago gives a 120-day moratorium, which will take you into mid-July, but then it also requires, in a non-payment case, another 30-day notice. So if you're in federal subsidized housing, they can't file an eviction until August 24th of this year. But again, don't ignore anything that you get. It's important, so important, that we look at those papers and be able to defend you in court should that happen. There are a lot of rules and regulations that apply to subsidized housing that don't apply to private housing. And so again, it's a very specialized area, and it is a very special benefit that you have if you are receiving a federal subsidy of any kind. So please make sure you reach out to us. There have also been some questions raised from time to time about fair housing issues, that is housing discrimination. I'll just briefly touch on that. The federal government has, through the Fair Housing Act, has anti-discrimination laws, which are enforceable in New York State, but actually in New York State, we have an even more robust fair housing law. So you cannot be discriminated against based on lots of things: your religion, your race, your ethnicity, your gender identity, your sexual orientation. All of those things are protected in New York State. So if you are being discriminated against, or you think that you're being turned down for those reasons, there are a number of resources to help you, and you can make a complaint in that regard. Our agency can help with that, as well as the CNY Fair Housing can also assist with that. And these protections apply not only to when you're trying to get an apartment or get a home, but to purchasing a home, and also to terms and conditions of a tenancy. There's a special, there are special protections. If you are a person who needs a support animal, or emotional support animal, or physically needs a support animal, there are protections for you. And so, if you have concerns about that, or it's something that you think is happening, it's good to reach out for help. So please remember that you can do that. And New York State is a good state to be in terms of protections against discrimination in the world of housing. I want to keep this, I want to make sure we have lots of time for questions. And I just want to reinforce what others have said. It's really important to reach out to us. We are available, and that's why we're here. We're here to try to help every tenant maintain stable housing as much as we possibly can. So remember that. And if you get served with papers, don't take it as a foregone conclusion that you're going to be evicted. There are defenses in almost every kind of eviction case. And we want to talk with you. We want to work with you. We want to draft written answers whenever possible. We want to get that to the court to give you your very best shot. One thing I can say with a lot of certainty is that if you are acting completely on your own without any assistance, you're not as likely to get as good a result as if you have an attorney. And we all represent agencies that represent low-income people, and you can get assistance for free, and it's worth every penny you spend. So I'm going to pass it back so that we can have an abundant time for questions. And I'll turn it over.
Excellent. Thank you so much, everyone. We have had several questions come through on the Q&A, and I thought maybe Marina could ask them and let everyone know what's out there.
Okay, from Kamala Chestnut. She has a tenant that is not paying rent, and her son is living in the residence. He is not on the lease. Also, complaints have been made about the dog living in the apartment, which I do not allow in rental properties. The tenant gave 30-day notice and was supposed to be out by the end of March, but is using COVID-19 to stay rent-free and adding family members in the apartment.
Lots of things come up when I see that. Lots of separate issues. First of all, people have a right to have their family members live with them, period. We can get into more detail about that, but he would have a right to be there. And I'm sympathetic to the situation that the landlords are finding themselves in, because tenants who had planned to leave are staying, and they have a right to stay. This is a public health emergency. This is an unusual time. So that's it. And you can still give notices as landlords about lease violations, but we're not going to be seeing eviction cases about any of those things for a while. And we really don't give advice to landlords just as a general matter of principle. So just wanted to throw that out there too. Our agencies actually really do represent tenants and tenant rights. Anyone else want to jump in there?
Miss Chestnut you can likely contact the County Bar Association and they can put you in touch with attorneys who do represent landlords. There are a number of them out there who would be able to give you advice as it relates to that particular situation.
I might I reinforce everything that's been said. I think maybe in future questions, we might be better off if we not identify either the tenant or the caller's name so that people don't feel exposed. And remember, as Laurie said, we can give general advice, but we are not here to solve your individual problem, and we don't want you to have to give up any personal information yourself.
Thank you.
Thank you for that, Susan.
Yes. If I have my landlord a 30-day notice, but find my new place isn't ready due to COVID, can I withdraw my notice?
I'll be glad to answer that. You should notify your landlord right away that you are not keeping the 30-day notice because of the eviction situation. You may want to, just in the interest of keeping things friendly with your landlord, tell them that if what you're planning to do is to take the new apartment when it's available after the COVID thing. But remember, even if you gave a 30-day notice and didn't get out, they still have to take you to court. They still have to serve a notice and petition to have you leave if you don't leave. So that will, again, give you some of that protective time that Diane talked about in her presentation. But in the interest of fair dealing and in order to not to create worse relationships with a landlord, I would simply advise them that it's just been delayed. And put the blame on Governor Cuomo. This is what we've all been instructed to do, is to stay where we are for the time being.
Okay, the last one is, what if the landlord gives a 90-day notice that the rent is being increased when the lease is up? The tenant signs the notice and notified the landlord verbally that they will not renew the lease. Is there any issues for the landlord or the tenant?
I guess I'm not sure what the question is really asking is what the issue might be. But if a landlord gives a 90-day notice that the rent is being increased, and that's the appropriate notice based on how long the tenant's been there, if a tenant signs a notice that acknowledges that they're accepting that, that the question is, what is the notice that, what are they signing? Are they signing that they're agreeing to renew the lease, but then tell them that they're not renewing the lease? So it's a different thing than just signing that they understand that the rent would go up. So you want to look at your paperwork really super carefully and know what it is that you're signing. So if it's that you're signing a new lease, then yeah, there might be an issue about that being enforceable and what comes next. But if you're just signing an acknowledgement that, hey, this rent is going to go up, but then you're telling your landlord that I'm not renewing the lease anyway, then there's probably not a problem. But anytime you are giving notice, it really is in your best interest to do it in writing so that you can document that I'm not staying even though you gave me this notice, or even though I signed this. So the issue I see there is that get it in writing, protect yourself.
Perhaps also the person is asking if the landlord can do that, if the landlord can give a 90-day notice and then after 90 days raise the rent. And the answer is yes. And then if you don't pay the higher rent, then your landlord can take you to landlord-tenant court for the shortfall. We don't have rent regulation laws here in the same way as there are in New York City.
To me, there's also an issue of whether or not there would be any obligation on the landlord to mitigate any damages coming out of this. If this was a lease renewal form that was signed and then the tenant chooses to break the lease early. Again, like Laurie was saying, you know, any notices you receive in writing, make sure you read them carefully. If you're not entirely sure what it is that's been presented to you, please, by all means, contact our agencies and we can help you understand what these notices require of you, what they require of the landlord, what your rights and obligations are.
So I was going to say there are two questions that appear in the chat, and so I'll ask that. Is it true that landlords can only ask for first month's rent and security deposit? They're no longer able to ask for first and last month's rent before renting a property?
Absolutely correct.
Yep.
Absolutely correct. They can't get first month's, last month anymore. They are restricted to a security deposit, which is equal to 1 month's rent or less, and the first month's rent to move in. Nothing else. Nothing else.
Okay.
What about pet fees, though? A landlord could ask for pet fees, right?
Not at the time of signing. I would definitely want people to be aware that if you are entering into a new lease with a landlord, that, as Susan said, security deposit and first month's rent are the only thing that is expected to be paid of you at that time. If there are any rental application procedures or fees that are part of obtaining the new tenancy, that should not be higher than $20 because the landlord cannot charge you for more than $20 to do a background and credit check combined.
Those are the only two things.
Mm-hmm.
Okay, and the next question. A tenant has a month-to-month lease and is trying to apply for SNAP and needs proof from the landlord. What does the tenant need to do to obtain this documentation?
Okay, I guess I will address that. Your landlord should do that. If they don't do that, SNAP is required to take other proof of tenancy. So a statement, any kind of a statement that you might make, rent receipts, that sort of thing, to prove the tenancy itself. If you have a lease, if you're month to month, you probably don't. But if you're paying rent and you have history of receipts, they can prove the tenancy otherwise than by a landlord statement. Although the landlord should provide the statement. But and if you're having trouble, if anybody is having trouble with that, we also can assist with SNAP problems and public assistance issues. So you can reach out to Legal Services of Central New York for that as well.
I see one question on here that says, just to make sure this information is only for the state of New York, or is it for New York City and state? And New York City has a lot of additional protections for tenants, rental, what am I trying to say here?
Rent stabilization.
Rent stabilization, that's what it is. So
Rent
there's some rent control and some other things involved. Oh, my brain. But this is New York State law, and New York State law changed a lot in June of 2019. Providing a lot more protections for tenants, and that some of those landlords out there may not really be aware of those changes, which is another reason why we wanted to do this. So what Rob was just saying, that $20 maximum fee, the new law saying that they can only charge first month's rent and a month's worth of security deposit at the time of signing, those are all new protections. The protections making self-help eviction an actual criminal misdemeanor with penalties of jail time and fines are also only new as of June 2019. So there's a lot out there to protect tenants' rights, and we hope everyone stays safe. Are there any other questions that we're seeing? Did I miss any? I think we're good. Last call for any questions. All right. Well, we will be sending out a follow-up email with some contact information sheets. I did also put in the chat our various organizations' phone numbers and contact information, but we will make sure that all gets out to everyone as well. I wanted to thank everyone. Thank you, especially Diane and Rob and Susan for participating, and Rachel and Monique for setting this up.
Thank you very
Great
much.
benefit. And thank you, Susan, for letting me go first so that I didn't have to speak super fast like I normally do.
We had one last question about where can they find these new laws?
Oh, perfect. The new laws, you can Google search ask our agencies, but they were all found in the Housing Stability and Tenant Protection Act of 2019, went into effect in June of 2019. Kind of very last minute overnight. So it was great. Anything else? Any other questions? No. Thank you all for participating. And if you need anything at all, please reach out. Thanks so much. And I think
Thank you.
Take care, everybody. Stay safe, stay healthy. Bye-bye.